Hello, everybody, and we're back, and we're kind of doing these things based on what's going on around us right now, which is what we do as lawyers. You just kind of react to the situation. So one of the things that I've decided it's important to talk about right now, because it is very in the news and discussed, and it involves the law, is the issue of qualified immunity. And you're hearing a lot of that right now. It's a debate in the Senate. There's a group that are trying to get the United States Congress to adopt a law that eliminates qualified immunity. And it's in the context right now is qualified immunity for police officers, but qualified immunity goes further than just the police. But because of the things that are going on in our country today, it's being pointed to, if you remove qualified immunity and you take that away from police officers, then you're going to give an opportunity for individuals to assert and have civil cases and be able to sue the police and the government, individuals in the government, for civil liability for excessive force and wrongful death and the things that go along with individuals being injured as a result of government employees, government actors, police officers, particularly in the debate we're having right now, while they're doing their work. Now, the theory of qualified immunity, the theory of immunity altogether, it finds its way back through ancient times. And immunity was something that was actually for the king and for the state. And the idea was that the king should be immune, and the king should be immune from being accused of doing wrong, because in reality, back many hundreds of years ago, the king or the royal family were considered to be in place and your leader as a result of God putting them in that position. Therefore, immunity for the government, the state, the king, which is where our immunity emanates from, was essentially saying, well, God granted the king the power to oversee and be the leader, and the queen, so you shouldn't be allowed to sue them, you people who are under their tutelage, under their power. So that's immunity, the idea of immunity. And judges have immunity from their actions, and there's a whole different discussion we'll have about judicial immunity and prosecutorial immunity. But the issue right now is the immunity for a police officer on the street. And one of the things that's really not being addressed is truly, if qualified immunity is removed and it would expand the ability to sue, it would then not subject these individuals to potential personally having to pay judgments and things, because insurance exists. But what qualified immunity, the reason that folks say that it's important to keep, is to prove a case today with qualified immunity, you must show that that government person, that actor, did something that was in violation of a completely, totally well-established constitutional rule, so to speak. And you have to prove that what they did was in a violation of something that they knew or should have known, or was reasonable for them to know they could not or should not have done. An example of this will be kind of the defense in the matter involving George Floyd. Now, there's many people that look at that and they go, oh gosh, there's a video and this gentleman has his knee on George Floyd's neck, and his actions are the result of George Floyd's death. Therefore, he should be liable and responsible because of what he did in their mind, and what they see is egregious. Well, the qualified immunity defense goes a little like this. Well, it wasn't a clearly established violation of a rule, because chokeholds and the method that officer was using is going to be argued was something that was allowable and allowed. Therefore, he has qualified immunity because he was engaged in conduct that can be, and in many instances is argued, is something that is allowable, that he did not violate a clearly established constitutional right or rule or statute by engaging in what they are going to argue is the conduct that is acceptable and was adopted and allowable. So there is no duty that was breached. There's no civil liability. That's going to be the argument, because qualified immunity is that important of a defense when you are the government that's acting, and when someone tries to sue you, that's your defense. So the other argument of the folks who are in favor of eliminating qualified immunity is, if you eliminate qualified immunity, then you put the police, in this instance we're discussing, in a place where they can no longer be free to act in what is perceived to be egregious manners, putting these on the individual's throats or the back of their necks. Some of the methods of using multiple taser inflictions, they become questions that the jury would decide. Is that excessive force? Do we believe, as individual jurors, as citizens, do we believe that that individual, that government actor, acted in a manner that is a civil violation? So the folks on the side of eliminating qualified immunity believe that the police will act more responsibly if they don't know or believe or have an idea that what they're doing is protected. And then the folks who say qualified immunity is important are the ones that say, well, we don't want the police to second guess themselves. So when an officer's on the street and something is happening, we don't want them to be thinking to themselves, well, wait a minute, if I do these things, am I exposing myself to being sued civilly? So that's the long and short of it, in a very simple way. Trust me, it's far more complicated, but in a very simple way, when you hear the discussion, the debate of eliminating qualified immunity, that's the crux of it. There's a belief that qualified immunity allows police officers on the street to act without hesitation, without being concerned or worried about getting sued. The individuals who are saying eliminate qualified immunity, their position is, but if they don't know any longer, they don't have that knowledge any longer that they are protected from their actions civilly, then they will not act in egregious manners or in manners that they believe that violate people's rights. And that's kind of summing it up. So that's the debate. And right now, as we're talking here on this 18th, 19th day of June, the Senate, which the majority in the Senate don't want to offer up a law that eliminates qualified immunity. Congress, the lower house, they believe that the elimination of qualified immunity should happen to help modify and change the behavior that is being displayed in many instances, as we see on television, involving police officers. Again, it does, I will say, qualified immunity makes it very, very difficult to file a lawsuit against the government and the government actors, because it is very difficult to prove that someone acted in a manner that was in violation of a clear constitutionally acknowledged rule, or something that they knew or should have known based upon the rules that were out there that they should have grasped. So it's tough. Qualified immunity makes it tough to sue folks civilly. The other side says you don't want your police officers, your firefighters, or other government people that are protecting you or doing whatever to have to think twice before they act. Again, that's a real quick explanation. Don't take everything I've said to be absolutely definitive. Do some research of your own. Don't just watch the news. Do some research of your own. Read a little bit about qualified immunity so you've got an understanding of what the debate is. Now, finally, I must always say, I am just talking about the law. I'm not giving you legal advice. If you need legal advice, call your lawyer. I'm not giving you that legal advice, but I am Larry Wilder. I am a lawyer, and I'm Larry the Law Guy. I look forward to talking to you again, and maybe we'll get to some of those other topics that we've talked about having discussion. Thank you very much, and have a great day.